Legally Speaking with me, Tarun Nangia. Now we commence part 2 of our series on dispute resolution mechanism and continuing legal education for judges. And in the part 1, we were all had the pleasure of listening to Justice Sikri, Professor Rajkumar, Justice Wilson, who shared their views. And of course, in part 2, we're going to look forward to hear Justice Sabrina McKenna and Justice Todd Edins. So let us, without much ado, begin. And Justice Michael Wilson had concluded part 1. May I request Justice Sabrina McKenna to give her views along with any facts and figures and data from the United States, and also her comments on continuing legal education for judges. Over to Justice Sabrina McKenna.
Thank you. In terms of dispute resolution, during COVID, one thing that has really happened in the United States is the increased use of remote technology for use of dispute resolution. Now our mediators are routinely using Zoom for mediations. And it's wonderful because Hawaii, as you know, is an island state. We have many cases involving litigants from the continental United States as well as other parts of the world. And now the mediators are able to conduct their dispute resolution through Zoom. And the mediators have learned how to use the breakout rooms so that they can caucus individually with one side or the other, and things of that nature. So that has been really good. Another thing that we have started in Hawaii is an online dispute resolution program for small claims court for litigants, so they can go online and have their cases resolved. So those are some of the new methods that have been a benefit of the COVID pandemic, when judges and the judiciary were required to learn the use of technology. And of course, that is also true for settlement conferences of judges, that they can actually do the settlement conferences using remote technology. And that has been helpful also. In terms of judicial education and continuing legal education, in part 1, the Vice Chancellor, I believe, mentioned that it is important that judges not just be trained by judges, but also by others. And I'm glad to say that that does happen in the United States. In terms of judicial education in the United States, as many of you are aware, we do have a federal judiciary as well as 50 state judiciaries. The federal judiciary has a federal judicial center that conducts its own judicial education nationally as well as regionally in different circuits. Different states have different judicial education programs. Some larger states like California and Florida have their own discrete programs where they educate their judges. But for smaller states like Hawaii, we enter into agreements through the National Judicial College. Smaller states pay into the National Judicial College, which is based in Reno, Nevada, and judges receive training through the National Judicial College. And I happen to be one of the faculty members there and do some teaching on state constitutionalism for the National Judicial College. Increasingly, there are also judicial education centers affiliated with universities and law schools. For example, the Berkeley Judicial Institute, the Duke Judicial Institute, as well as the George Mason University Antonin Scalia Law School's Law and Economics Center Judicial Education Program, of which I happen to be a member of the advisory board. And so these programs not only have judges, but also academics teach on cutting edge issues, including the ones that Justice Wilson and Justice Sikri discussed in part 1. But we hear from academics. And increasingly, what's good to me about, for example, like the Berkeley Judicial Institute, I attended a 3 half-day program from last weekend called Judiciary, Berkeley Judicial Institute and Judges. And we heard from academics, including the Dean Chemerinsky, about legal education in the United States, trends in the United States, but also very important other issues. Because judging, continuing legal education for judges is not just about knowledge, not just about the law, but it also involves skills. how judges can work through courtrooms. But increasingly, there's more attention on attributes of judging, cognitive functioning, cognitive things that happen, implicit bias, how judgments are affected by well-being, things of this nature. And so what's wonderful is when we have academics that are able to bring in the cutting edge research that they've done and educate judges on some of those things on all three aspects of judicial education. Thank you.
Justice McKenna, thank you so much for that opinion also on the Judicial Academy. One thing about skill development, which you said, I remember having done a show with Justice Sikri some time back when we discussed how important it is for judges to learn how to author judgments. Because, when we discuss it at length, that, there should be some training, because in India, lawyers get elevated as judges. It's a completely different thing to be at the bar and then be on the bench. As also authoring arbitral awards, but that's for another day. But this is what I recollect. But thank you for your comment. I'll go to Justice Todd Edens for his comment. Over to Justice Todd Edens.
Thank you, Tarun. I am absolutely delighted to be here. Aloha. Let me start just on a point that you just made. All judges were one-time lawyers. And most lawyers really simply specialized in one field or another, maybe a handful of fields at most. I have a criminal law background. I also have a civil litigation law background. That's my background. But I was not experienced in environmental law. I was not experienced in foreclosure law or any of these other types of law. So it's absolutely vital for judges. You can't just read cases and understand the law. The judicial education that goes hand in hand with learning substantive legal areas is absolutely critical. And so as far as, legal education, it's not just that. It's not just the technical expertise and the substantive law that you might need to know that you didn't know. It's also, as Justice McKenna was saying, the other aspects of judging, the aspects that often get overlooked, and that's integrity and civility and tone and demeanor and those types of judicial attitudes and qualities that really make for a wonderful judiciary. A well-educated judiciary really does mean the difference between justice served and justice denied. And the litigants that come before you and the parties that come before you, you can have the greatest technical and substantive expertise, but if you've got no interpersonal skills and no ability to relate to the people who are there to redress their wrongs, then they will walk away. They will leave the courtroom feeling like they weren't heard. And I think one aspect that we do in Hawaii that we really emphasize, and Hawaii has a mandatory judicial education system. We have twice a year sessions. All the judges get together, the new judges, the old judges, and we talk about these issues. Justice McKenna has advocated for well-being, and I think it's absolutely critical for our judges to have personal growth and to feel healthy and good about, and to take care of themselves. Because if you don't, this is a tough, stressful job, and it's going to show through to the litigants if you are not caring for your well-being. And I really admire Justice McKenna for bringing that area of judicial education to the forefront, at least in our training. In terms of alternative dispute resolution, I commend Justice Sikri for his efforts in trying to get through that backlog that the Vice Chancellor has talked about. It's quite frankly, 30 million cases is staggering. It's in the United States, there's similar backlogs. I mean, there's queues of cases, and the queues of cases actually got longer because of the pandemic, because we weren't, operating in full court mode. But, we did do remote hearings. That has cut down on some of the cases. Aside from, there just needing to be solutions to conflicts outside the traditional legal court system. It's daunting. The normal person is really, really intimidated by going to court. So if we have these mediations and arbitrations with well-trained mediators, that goes a long way in helping the parties really reach resolution. We have, as I mentioned, backlogs in our system. And one good thing about mediation, and we have mandatory mediation for most of our cases. There, you can opt out of mediation, but we have, requirements in our Hawaii law that parties actually have to go to mediation. Now, it doesn't work sometimes, and then you jump into the court system, then you go before judges, but at least you've had that opportunity to try to get together. We call it in Hawaii, ho'oponopono, getting together, meeting the minds, trying to work on our problems. That doesn't work, then we go to court. And that goes a long way in reducing the cost of litigation. The cost of litigation compromises access to justice. People cannot or feel like they, I can't really redress my wrongs. I can't, because it's so expensive to go to court. Mediation is one aspect of really reducing the costs. It's also confidential and there's flexibility in that. So I really, really admire the efforts in your country to work on just, trying to get people together and mediate and do alternative resolutions, because it has worked in our country. Thank you very much.
Thank you, Justice Todd Edens. In fact, a lot of empathy also came out from what you spoke, that judges should empathize when they're sitting in judgment in courts over various people who come. That is an important quality, I think, among many other things you said. I'll go to Professor Rajkumar at this point. Well, when we speak of continuing legal education, I remember the roster system that we have in our judiciary, when suddenly the roster gets changed and a certain judge with a certain background in terms of, maybe non-commercial gets to judge commercial matters. Do you think these are problems to which there are no easy answers? Because, and how do we deal with this at the college level or continuing legal education for judges? Because as also what Justice Todd Edens pointed out, that as an advocate, one may have a specialization in very different kind of cases, and we end up judging different kinds of cases when we are elevated to the bench. Could you please say in brief, explain how do we address this challenge that we are facing even in India?
Yeah, great. Thank you so much, Tarun. I know the time is short, so I'm going to be telegraphic in the sense, I believe that any continuing legal education program for judges should be based upon 5 principles and ideas. First, the continuing legal education program for judges should have a strong component on efforts to go beyond the law. The idea of interdisciplinarity, engaging judges to be comfortable with the study of law and economics, law and sociology, law and politics, law and anthropology, and other areas which are impacting law. In fact, this is one of the biggest challenges that we're facing today, because judges need to have the kind of broader humanities and social sciences perspective many a time when it comes to adjudication, and that's something which the CLE program for judges should focus on. The second is that any CLE program for judges should have a strong emphasis on comparative law and international law, bringing into their perspectives. Because many a time what ends up happening is, what we don't realize is that judges around the world are part of a larger conversations that is happening, which Anne-Marie Slaughter, a very distinguished academic, talked about transnational judicial conversations. This idea of transnational judicial conversations in which judges belonging to common law jurisdictions, civil law jurisdictions are ultimately advancing the cause of rule of law. And many a time, this is brought in a very ad hoc manner when it comes to judges being introduced into some judgments in some courts by the lawyers. But those may be very limiting in its approach. I think it's important from a pedagogical standpoint that the judicial training and education should bring in comparative law and comparative adjudicatory experiences from different courts into the curriculum. The third principle, which I am strongly committed to, is that these should be based upon an independent functioning arrangement, not only limited to the judicial academies, but also law schools should play a very big role. Because at the end of the day, the interpretation of law, the evolution of law, the critical engagement with law is being advanced by law academics and law researchers. And this should be brought to bear when it comes to doing these courses within the judicial academies. The fourth thing, which I was quite amazed many years ago, is that when I was teaching in Hong Kong, we had a partnership with the Supreme Court in China. And what would happen is the Chinese judges we had a tie-up where the master's degree in Chinese and comparative law was given as an opportunity for these Chinese judges to pursue, and there were different specialization. I strongly believe that most of our judges, I mean, Justice Sikri is an exception. We all know that he has a strong academic inclination. He used to teach at Delhi University. But I must say, most judges are, they have a law degree and they entered into legal practice or became a judge. The opportunity to go deep into an aspect of law through a master's degree is limited. And obviously, they can't quit the job. We need to provide flexibility and innovation when it comes to using both technology and asynchronous learning platforms and a bit of live classroom experiences and an in-campus experience, so that some of the judges at least should be able to pursue a master's degree. And the last bit is, and this is something which many judges have said it, which is that those who are serious about pursuing a deeper understanding of law, a doctoral program opportunity should also be provided for the judges. In some ways, we need to reimagine the entire judicial training and education program that we have so far done, which I believe doesn't do justice to the kind of aspirations and the demands that and the expectations that the adjudicatory process have on the judges.
Professor Kumar, thank you so much for that in-depth, in a sense, view that you shared with us. And I hope that with the kind of position you hold, we will see something on that too from your end in the coming days. It is now not uncommon to see that a lot of law firm managing partners, a lot of senior advocates go and teach judges, young lawyers who are practicing, relatively younger lawyers who are practicing in different diverse areas, do that. I will go to Justice Sikri now for his opinion on, in this dynamic changing environment where the nature of litigation has changed greatly. A lot of foreign investment has come to India, and the kind of disputes which happened on the construction infrastructure technology side have changed. Of course, drones is other element which I think Justice Wilson brought in. A lot of, there are issues like food delivery. So many things are happening which will lead to litigation which we never envisaged before. Could you please share your views on how do we progress from here? And of course, the roster system that I spoke about, many times judges who don't have experience as lawyers in a certain matter get to judge on matters which they never practiced in. Do you think that is also our dilemma now, how to correct that? Your views on that?
So very pertinent and important issue which you have raised, and Professor Rajkumar has already laid the foundation there too. As I said in part one also, that how the dynamics of litigation is changing, the nature of disputes which is changing, which we never studied in our law colleges, and now we are grappling with that. And that calls for judicial education. And here, of course, what we have said about these construction disputes or other disputes, as I mentioned earlier as well in the first part, that the complexity of these disputes is changing. Arbitration, I remember when as a lawyer in the 80s and 90s, early 90s, I was doing arbitration as a lawyer. The issues were totally different, and domestic arbitrations of very, the nature was a short kind of disputes and not much of stakes involved. But all that has undergone very, paradigm shift. Today, as I said, international disputes are there. We are, where the issues are very, very complex. I have seen in one or two cases where we have written the awards in international cases, international arbitrations, they run into 400 to 500 pages, where we have to grapple with so many issues. So therefore, it calls for judicial training. And the 5 factors or 5 aspects of judicial training, which Professor Rajkumar has highlighted. And let me comment on that. Number 1, that some of these are already adopted in India, as Justice McKenna also mentioned about it's not only the legal, acumen, etc., or knowledge of law, but the skills, other skills which are required, how to analyze the evidence, how to have empathy in a particular matter. So those kinds of skills are also needed. And therefore, one thing, now let me start what we are having in our judicial academy. We also have National Judicial Academy in Bhopal at national level, and all state high courts are also having their judicial academies. There are, there is a cooperation between some of the judicial academies, and not only within India, like I know in National Judicial Academy and even in Punjab and Haryana High Court Judicial Academy, the judges are coming from Bangladesh, Sri Lanka for training, because I have been there as a resource person in some of these trainings. And likewise, our judges are going. We have Commonwealth, this judicial training program, and this is Judicial Academy is based in Canada, Halifax, where every year from India, few judges go there for 1 month in June, sometimes from the High Court, sometimes from the district courts. So those kinds of interactions are there, where he's, Professor Rajkumar talked of the comparative analysis and how we should know what is happening in other countries, etc. But yes, lot is to be done. Let me here add that in the judicial academies, whether it is national or state judicial academies, it is not only judges in India as well. We have many lawyers coming. And I have some of the programs in last 2 or 3 months, which I have done in National Judicial Academy on arbitration and on intellectual property, etc. Lawyers were there, and many times teachers are there. Now, something more, which I think Justice Edins mentioned about the judges, they are working under stress, etc. Many times in the judicial academies in India, we invite psychologists and counselors. So how to fight this stress in your life and how to manage your life. So those kinds of training programs are also there along with that. I welcome the idea of judges doing post-graduation and even doctoral opportunity if it is given to them. I tell you, frankly, when I was in my last years of in the Supreme Court, just before my retirement, I used to think that I'll do PhD after my retirement. I may have some time. Maybe, yes, now I think I should enroll myself in OP Jindal Law School and do it. Fortunately, I'm already done LLM as a student itself. But one thing, let me tell you, there are rules in judicial service for subordinate judiciary that if you pursue higher courses like LLM and PhDs, they are given special increments in their pay scale. So there's already that kind of environment is there which encourages them to do better in academics also and learn this. So of course, what we need is that there should be not only, it should not be ad hoc. It should be, there's some kind of thought we should go into it, and we should have some comprehensive scientific program which should be developed. And I feel, and very strongly feel, and today my, this conviction is becoming stronger with what Professor Rajkumar has said, that there should be some cooperation between judicial academies and law schools as well, so that they are able to gain from each other. That is also very, very necessary. So that is how we'll be able to develop the skills of our judges, and so that they are able to perform well. Your last, I will take only 1 minute in answering that question. You said that about the judges who are, say, not very well conversant with commercial laws or some special laws like intellectual property, etc., or some other law, and or maybe suppose I have not done criminal law at all as in practice, and now I'm heading a criminal bench. So how to deal with that? It not only calls for judicial education, I would say, that because there was no judicial education earlier also, but there, of course, judicial education is necessary. But there is something that judges, and I can say on behalf of, I think my guest from America or Hawaii would also concur with me on this, that the judges have this knack that over a period of time that expertise comes. I tell you, intellectual property, I had not done a single case as a lawyer. And when I sat, and the kind of cases which used to come, as in Delhi High Court on the original side, and I was chosen as one of the most most influential person in the world in intellectual property in 2007. So because of some judgments which I had given. But you are able to learn. But yes, there has to be, this interest for learning. Otherwise, judicial academies and law schools are there for this.
Thank you so much, Justice Sikri, for that. But I must qualify it with that. People would know, but Justice Sikri has been a gold medalist at college. So that academic bent of mine shown from there. And secondly, with your schedule in arbitration, I doubt you'll get time for any continuing legal education as of now.
But Tarun, I am so delighted that we have a potential doctoral student in this program. So we will have an offline conversation on that.
That's a good one, but it's a very positive and good note to end the show. But it was a pleasure moderating these two sessions. We had varied opinions. We had experience on the judicial side, experience on the academic side, people from different geographies. That makes for a beautiful panel. You know, this is like a beautiful bouquet where you get varied opinions and each one more valuable. I would like to thank Justice Arjun Kumar Sikri, Professor Raj Kumar, Justice Michael Winsel, Justice Sabrina McKenna, Justice Todd Edins for making this special, giving all your opinions. And I'm sure my viewers, this would have been a pleasure for you watching this. Thank you so very much and looking forward to see you again. Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.